This week, Papua New Guinea's political stage took another dramatic turn, clarifying a crucial constitutional question. The Supreme Court has clarified one of the most misunderstood questions in our constitution. When can a motion of no confidence be lawfully moved against a sitting Prime Minister? On November 27, 2024, a notice of motion of no confidence was filed against Prime Minister James Marape, nominating Grand Chief Sir Peter Ipatas as the alternate Prime Minister. However, the Private Business Committee rejected that motion, citing Section 165 of the Standing Orders. Feeling the decision was unlawful, outspoken member for Chuave, James Marape, took the matter to the Supreme Court under Section 18 of the Constitution. While that case was still pending, Parliament quietly amended Section 145 of the Constitution in March 2025. This amendment introduced a new rule. No new motion of no confidence could be moved within 18 months after a failed one. The change became law on March 17, 2025. Then just 2 weeks later, on March 31, 2025, the Supreme Court handed down its ruling in the Somare case, SC 2721. The court said something simple but powerful. The amendment had no retrospective effect. Under Section 110 of our Constitution, a law can only apply backward if it clearly says so. This one didn't. That means the amendment cannot affect the November 2024 motion that named Sir Peter Ipatas. The court said, "We will interpret and apply the law as it stood on November 27, 2024. In short, Parliament cannot use new laws to block old motions." Now fast forward to today. The new notice of motion dated October 29, 2025, nominating Hon. Peter O'Neill as the alternative Prime Minister is the first legitimate motion under the new law. It is not a repeat of the Ipatas motion because the 2025 amendment does not apply retrospectively. And here's the key takeaway. The government will only enjoy its 18-month protection under Section 145 after this new motion is defeated in Parliament, not before. There's also been talk about whether this motion conflicts with the Supreme Court application by Hon. Alan Bird. It doesn't. Both cases fight for the same democratic principle that Parliament, representing the people, must always have the power to hold a Prime Minister accountable. No law should ever silence that voice. For Papua New Guinea, this is bigger than political rivalry. It's about preserving the balance of power between Parliament, the executive, and the people. As events unfold in the coming days, one question remains. Will Parliament use this moment to defend democracy or to protect political convenience? In conclusion, the question on everyone's mind is the vote of no confidence motion filed on the 28th of October valid or defeated as per the Private Business Committee's response? In our view, as explained above, the new motion is not affected by the new law and thus is still effective. Stay tuned for more updates on this new turn of events and subscribe to our channel for the latest political news, analysis, and updates.